My name is Will Beck, and I'm the Assistant Managing Attorney on the Right to Counsel program here at Tacomaprobono's Housing Justice Project. I'm here today to go over the 3 documents that are essential to any landlord starting an eviction lawsuit, also known as an unlawful detainer action. Those 3 documents are the notice, the summons, and the complaint for unlawful detainer. The purpose of this video today is to go over what each of those documents mean and what each of those documents intend to do. Also, we want to go over these documents to make sure we're distinguishing one from the other so that if you get one of these documents, you'll know exactly what they mean. So let's go ahead and get started. So we're going to go ahead and get started with the notice itself. And with the notice, this is what commences the unlawful detainer action. You'll see what I have here on the screen is a 14-day notice to pay rent or vacate the premises. So if you've fallen behind on rent, this is likely the notice that you'll get. Just note, if you're facing eviction for something other than non-payment of rent, you could be receiving a different notice other than this 14-day one. So this one's just an example. But for the purposes of using it as an example, you'll see here this is a notice. It gives the tenant information about how much they owe, how much is due. It gives them a time period in terms of how soon they have to pay that or vacate the premises. It also gives some information about the right to legal representation, which is what my office provides. We are the right to counsel entity here in Pierce County, and so there's some information there. If you get one of these notices, what this notice will direct you to, but this particular notice, is to either pay rent or vacate the premises. Different notices will have different time periods and different requirements. Some notices, so if you receive a notice for waste or nuisance or unlawful activity, you may not have the option of curing that notice and preventing the eviction from going forward. So this, again, the notice itself is what commences the unlawful detainer action. And if the landlord chooses to take the next step in the unlawful detainer process, after the expiration of this notice period, if there's a cure opportunity in the notice and the tenant has failed to cure or correct whatever issue is being alleged, or if the notice does not have the opportunity to cure and the landlord has given that notice and the tenant that time has expired for the tenant, the landlord will then move forward with a summons and complaint for unlawful detainer. And so summons and complaint, although those words are used in tandem, refer to 2 separate documents. And so we'll go through each individually. We'll start off with the eviction summons, and it's really important that we know what exactly this document is asking us to do, because there are some serious implications if we don't know what we're doing with this document. So the eviction summons is essentially the way of giving notice to the tenant that this unlawful detainer action or lawsuit is being started, and it's also a way to compel the tenant to give a response to the landlord. The response to the landlord is necessary. Otherwise, if the tenant does not give a response to the landlord's attorney within the specified time in the summons, the landlord can actually go forward with a motion for default. And what that means is that they can go forward essentially as a forfeit. You haven't responded, they don't know that you're going to appear in the case, and so they're going to proceed without you and get the relief that they're requesting. So if you're being evicted for non-payment and you don't respond to your summons, it's very possible that the landlord would go forward with a motion for default and seek to get a judgment against you in court for the money that you owe, along with attorney's fees and costs, and a writ of restitution, which is a court order directing the sheriff to remove you from the premises. So we'll just kind of go through the aspects here. Again, you'll see in bold letters here, your written response must be received by, and there's a date on there. So make sure you understand that is not the date you have to leave by. That date is in the notice. This is the date that you have to respond by, and it also goes forward to explain how you would respond. Here and how to respond, and this is language that's required by the statute. So there's not necessarily a lot of variation that can go on here. For the most part, landlords have to substantially comply with the language that's in here. You'll see that you can respond by giving the landlord a letter that has a statement that you're appearing, names of the landlord and tenants, and also your name, address, where legal documents may be sent, signature, phone number, and case number if the case is filed. You'll also see that I highlighted these boxes here to indicate whether or not the case is or is not filed with the court. Generally speaking, if the box for is not filed with the court is checked, that means, of course, the case has not been filed in court yet, and you'll have some more time before a hearing date is set. But don't let that fool you. Regardless, you want to get in and respond as soon as possible, because the earlier you can get in and respond, the earlier you can seek the assistance of counsel and get some help with this eviction proceeding. It also gives you information on where to respond. There's some very specific requirements on where to respond. You either have to mail your response, fax your response, or hand deliver your response to the landlord's lawyer, or if they don't have a lawyer, to the landlord directly. Not all attorneys or landlords will have the fax option, so in some cases you may be left with either mailing or hand delivering. And if those are the only two choices that are available to you, you may need to plan ahead so that you can get the mail there in time, or so you can have time to go down to that attorney or your landlord's office to hand deliver your response to the summons. Now, oftentimes, the summons will be paired with the complaint for unlawful detainer. And the complaint doesn't necessarily require an immediate response. However, what the complaint's purpose is to set forth the allegations that are being made by the landlord. So this is kind of the landlord's opportunity to tell their story and make their request for the court for the relief they're seeking based on that story. So for example, if you haven't paid rent, the complaint's likely to say something like, on this date, we sent a 14-day notice to pay rent or vacate to the tenant. They did not pay rent or vacate within the 14 days. We're going forward with this eviction, and we'd like a writ of restitution and a judgment for the money that's owed. So again, the main purpose we're including the complaint in this video is to distinguish it from the summons because of how important that summons is, namely the importance of responding to that summons. So that kind of distinguishes the three documents that you're common to see in every single unlawful detainer proceeding. If you receive a summons and complaint for unlawful detainer from your landlord, please contact Tacomaprobono as soon as you can so that we can conduct a screening to determine whether or not you're eligible for the right to counsel.
And there you have it. So I hope with this information you'll be able to better distinguish the difference between a notice, a summons, and a complaint for unlawful detainer. If you get a summons and complaint for unlawful detainer, please contact our office immediately. We are the sole entity for the right to counsel for eviction cases here in Pierce County, and we hope to be able to help you. Thanks for watching, everyone. Hope to see you again soon.